The SLV, what it wants, needs, and deserves. Ann Kelly, the Republican Ann Kelly, is victorious. She defeats Robert Willett in the midterm elections, November 2022. Ann Kelly says, I think it says a lot about what the Valley wants and what the Valley needs and what the Valley deserves. She also said the SLV voted for change. She might have said the Valley, but she's saying that we voted for change and for an opportunity to move forward. She and her team have an incredible mandate in front of them. That sounds progressive. Voted for change, for an opportunity to move forward. Now, Robert Willett, what did we lose out on? He was talking about the LEAD program and a diversion program that were implemented prior to Alonzo Payne taking office. He thought that there was those programs were good, diversion program and the LEAD program, and he also said there's a whole spectrum of corrective measures in the system, and if people do stupid things, well, stupid can be fixed, can it? Evil things, however, evil things not so much. This is Robert Willett. He was the DA around here, deputy DA for at least, 5, 6, 7 years, but not prosecuting serious crimes. That's not criminal justice reform, it's malpractice. Plea deals are also common. Plea deals are also common, says Robert Willett, adding that 95% of all the cases in the country are pled down. The question is, what is a just outcome in this case? Some cases are no offer. Murder, sexual assault. If somebody is charged with murder and it's pled down to a third-degree assault, that's not a just outcome. That is why communication with victims is crucial, Robert Willett adds. Even if victims are angry and yelling, it's the prosecutor's job to listen and to try to explain. But in some cases, it's also necessary to go to trial. Robert Willett said, adding, he's done close to 100 jury trials, including a felony trial in every county in the Valley. You have to be prepared to go to trial if need be. Christopher Hitchens says terrorism works better as a tactic for dictatorships or for would-be dictators than for revolutionaries. I can't stand terrorism as a tactic. Don't attack the civilians. How's that going to win hearts and minds when you're attacking the civilians? Now, I believe this is actually really important for the DA and the 11 judges and the 46,000 souls in the SLV, Mineral County, Rio Grande, Saguache, Alamosa, Conejos, Costilla. The 10-step criminal procedure for Colorado is as follows. Number 1, the arrest summons. 2, bail bond hearing. 3, advisement of charges. 4, preliminary hearing. 5, dispositional hearing, arraignment. 6, 7, motions hearing. 8, pretrial readiness conference. 9, jury trial. And 10, sentencing. Now, this is a criminal procedure for a felony charge. I've been charged with a Class 5 felony. Felony menacing is what they're charging me with, for firing a couple warning shots and telling some hooligan to get out of my neighborhood. What I have figured out for the San Luis Valley, for the judges and the brand new DA, is at least 9 of these steps. All these steps actually come from the Right Law Group. So I got it on the internet, but it's from a group that works here, so they can't just lie about stuff. And I read all the CRCP just to make sure it all lines up, and it's a good rule of thumb. Now, Michael Gonzales and I actually disagree on 1, the preliminary hearing. I have a Class 5 felony, and so his argument is something about that there's not a minimum jail sentence. So typically there's like a whole list of specific crimes that if you're charged with these specific crimes of violence, then you get a preliminary hearing. Also, if you're in custody. So a lot of times a preliminary hearing is for a person in custody. Preliminary hearing is also a way to preserve all the evidence in the beginning. A preliminary hearing is also a way for the defense to ask a couple questions of the arresting officers and of the complainant to, face their accusers a little bit. And also just have a mini trial. What kind of evidence do we have? What are we talking about? What's the situation, and what are we talking about here? Now, this is important. I'm going to find a CRCP. I'm going to find CRCP just to talk about Rule, 6, a preliminary hearing? Yeah, Rule 5, preliminary proceedings. The preliminary hearing, county court procedure. So I'll just read this, okay? So this is under Rule 5, part number 4. Preliminary hearing, county court procedures. Every person accused of a class 1, 2, or 3 felony and a felony or a level 1 or 2 drug felony complaint has the right to demand and receive a preliminary hearing to determine whether probable cause exists to believe that the offense charged in the felony complaint was committed by the defendant. In addition, only those persons accused of a class 4, 5, or 6 felony or a level 3 or 4 drug felony by felony complaint, which felony requires mandatory sentencing, or is a crime of violence as defined in Section 18.1.3406, or is a sexual offense under Part 4 of Article 3 of Title 18 CRS shall have the right to demand and receive a preliminary hearing to determine whether probable cause exists. However, any defendant accused of a Class 4, 5, or 6 felony or a Level 3 or 4 drug felony who is not otherwise entitled to a preliminary hearing may request a preliminary hearing if the defendant is in custody for the offense for which the preliminary hearing is requested, except that, upon motion of either party, the court shall vacate the preliminary hearing if there is reasonable showing that the defendant has been released from custody prior to the preliminary hearing. Any person accused of a Class 4, 5, or 6 felony or a Level 3 or 4 drug felony who is not entitled to a preliminary hearing shall, unless otherwise waived, participate in the dispositional hearing for the purposes of case evaluation and potential resolution. The following procedures shall govern the holding of a preliminary hearing. Within 7 days, Okay, so let's go back to what we have disagreed on. So he's essentially saying I'm not in custody and I'm accused of a Class 5 felony, so it's not one of the big felonies. It's a big enough felony to take all my guns, right, to deprive me of my Second Amendment and my Article 2, Section 13 rights and freedoms, and also a $5,000 bond and to have over 12 court appearances, and also Class 5 felony. It's big enough to threaten me with 3 years in jail and $100,000. And my argument is because a Class 5 felony, the minimum, there's a floor. A Class 5 felony says at the very minimum, you're going to serve 1 year in jail. If you're convicted, you're going to serve 1 year in jail. And since it has that minimum, therefore, I'm due a preliminary hearing. So I'll read this again, but he's saying that it's a Class 5 felony charge, so it's not worth it. I'm also not in custody, so it's not worth it. I'm saying that there's one part here where it totally matches, right? It says you get a preliminary hearing on this or that or this or that. It says or like 4 or 5 times in the very top, right? Let's read it again. Number 4, preliminary hearing, county court procedures. Every person accused of a Class 1, 2, or 3 felony and a felony or a Level 1 or 2 drug felony complaint has the right to demand and receive a preliminary hearing to determine whether probable cause exists to believe that the offense charged in the felony complaint was committed by the defendant. So that doesn't apply to me, right? Class 1, 2, or 3, those are the bigger ones. Class 1, 2, or 3 felonies. Those are the 5 is and 6 is the bottom. Number 1 is the top. In addition, only those persons accused of a Class 4, 5, or 6 felony or a Level 3 or 4 drug felony by felony complaint, which felony requires mandatory sentencing, or is a crime of violence as defined in Section 18.1.3406, or is a sexual offense under Part 4 of Article 3 of Title 18 CRS shall have the right to demand and receive a preliminary hearing to determine. So which part am I talking about? I'm talking about which felony requires mandatory sentencing. If there's mandatory sentencing, 1 year in jail, that's mandatory sentencing. And then I think there's a mandatory minimum fine too. Isn't there a mandatory minimum fine? Let's check that out. So we're going to look at the felonies. So mandatory minimum fine. Let's check out what happens when you have, Class 1, Class 2, Class 3, Class 4, 15. What do all these classes mean, right? What the heck are we even talking about? Class 1, Class 2, Class 3. Goodness freaking gracious, right? So Colorado criminal penalties, Class 1, 2, 3, 4, 5, 6. Right? These are felonies. 1, 2, 3. Felony presumptive range of penalties. Misdemeanor drug offenses, petty offenses, misdemeanor. So, okay, we're going to stick with the felonies. These are committed on or after July 1st, 2020. And this was from before, so we're going to stick with this page right here. So a Class 5 felony, the minimum amount that you can be charged for a Class 5 felony is $1,000 or 1 year in jail. That's a minimum. That's a mandatory sentencing. Isn't that what it says? Mandatory sentencing or mandatory punishment? Let's go back and read this preliminary hearing thing again. In addition, only those persons accused of a class 4 or 5 or 6 felony or level 3 or 4 drug felony by felony complaint, which felony requires mandatory sentencing. Yeah, that's mandatory sentencing, right? That's at least $1,000 fine and 1 year in jail. Because it's a minimum, because there's a floor. And there's a floor for all the felonies. 6 is 1 year and $1,000 fine too. So 6, 5, 4, 3, 2, and 1. 8 years, 5,000, 1 year, 1,000. That's the minimum penalty. And then the maximum is 24 years and $1 million and 100,000, 2 years. Okay, so 4 years. Maximum penalty has gone up for, that's extraordinary risk. Okay, so not extraordinary risk is 3 years on 100,000. And then mandatory parole period is 2 years. So 3 years in jail, $100,000. Mandatory parole period. So in 2 years at the very least, if I was just to be like, yeah, shooting a couple warning shots, I wasn't actually defending home, person, and property like Article 2, Section 13 specifically states. No, I was doing something else. No, I was doing what you say I was. That's what, I wasn't doing a private police action of get out of my, I wasn't trying to defend my dogs and my home and my person and property against a hooligan. No. So, because felony, class 5 felony carries a $1,000 minimum fine and a 1 year minimum sentencing, therefore, I'm entitled to a preliminary hearing. That's the biggest argument that me and Michael Gonzales has had when it comes to these 10-step criminal procedures. So he doesn't have a problem with any of the other ones. And in fact, we've actually had all the other ones. We've had an arrest summons. We haven't had a bail bond hearing, but the bail bond hearing, I guess the police officers kind of done the bail bond hearing with the bail bondsmen. And so we did that on our own. So we didn't really need one, but maybe we should have one just to keep it all on the up and up. But arrest summons, bail bond hearing, advisement of charges, preliminary hearing, dispositional hearing, arraignment, motions hearing, pretrial readiness conference, jury trial, and sentencing. So we've actually had all these: dispositional, arraignment, motions hearing, pretrial readiness conference, not sentencing or the jury trial, but everything else, advisement of charges, bail bond hearing, arrest summons. Me and Michael Gonzales, we agree on every single one of those things except for the preliminary hearing. And it's not that he disagrees with the preliminary hearing. He just disagrees with the preliminary hearing in my case, a felony menacing charge, class 5 felony. He doesn't believe is entitled to a preliminary hearing. And I think that's bullshit. I think that's totally wrong. But regardless, let's give him the benefit of the doubt. Let's say he's right. So what he would say is that these 10 steps are for all the felonies except for the preliminary hearing, which, half of the felonies they get the preliminary hearing and the other half do not. So Michael Gonzales agrees with the arrest summons. He agrees with the bail bond hearing. He agrees with the advisement of charges. He agrees with the dispositional hearing and the arraignment and the motions hearing and the pretrial readiness conference, because we've had all of those hearings so far. All those hearings are some kind of, modified. The dispositional hearing, it took forever. I couldn't get the DA to look at me or talk to me, and they didn't want to talk off to the side. They're just trying to twist my arm to get a plea bargain, right? But how am I going to even... Anyways, they started to take the people into the back and actually just kind of, here's what we're looking at, here's the case, and kind of talk about the case a little bit. I found a law that said that judges are not allowed to be a part of the plea bargain. And I wonder if the judges have been getting right in the middle of the plea bargain and saying, no, you need to do this and you need to do that. A lot of times DAs and judges, they seem to want to think that the more convictions that they have and the more, draconian, the more, the shittier they are, right? The bigger the sentencing and the bigger the punishment and the more people that they convict, the better of a DA or judge. I don't want you to convict a whole shit ton of fucking people. I don't want you to go around just using the system as a bludgeon, felony menacing everybody. What I want from the system is I want a peaceful society. I want public safety. I want safety, security, peace, freedom, love. So the truth, justice, peace. I want the presence of justice, so therefore we'll have a peaceful society, and then we can, be Americans. We can go get a job and go protest and go do this and go do that. But if we're going to be trying to attack one another, if we're going to be a bunch of barbarians, then none of these laws and rules even matter, right? So at the very least, Michael Gonzales and I agree on 9 steps completely for a Class 5 felony, sentencing, jury, trial, pretrial, readiness conference, motions hearing, arraignment, dispositional hearing, preliminary hearing, advisement of charges hearing, bail bond hearing, and an arrest/summons. So we agree on those 9 steps with the preliminary hearing in doubt. I believe I'm entitled to one. He did not. And actually, the first time he made his ruling, I don't really think he thought about it that much. And, typically probably use preliminary hearings just to get people out of custody, right? If they're in custody, then, okay, let's see if they're actually, if this is actually big enough to keep this person in custody. So I could see why he would think that there would be, a pressing interest in order to do a preliminary hearing if you were in custody. But you can't just file frivolous felonies. And in Kentucky, they had a grand jury indictment. There's a grand jury in Kentucky. I don't know why they don't have it here. I think they have it here. They just don't use it. But both the U.S. Constitution and the Colorado Constitution kind of dances around it. But essentially it says the same thing. You can't just have a frivolous... One asshole can't point to another asshole and say he's a felon. It's got to go... grand jury has to put down the indictment. And if they don't have the indictment, then it's got to be something else. And so what they've done as a preliminary hearing is kind of the grand jury, sort of indictment, because you don't need a huge grand jury to do the thing. The whole idea of the grand jury is that there's probable cause that a trial, a regular jury trial, should, proceed forward. We could figure that out with a preliminary hearing. A preliminary hearing is kind of a mini grand jury. Hearing to look for... It's like a probable cause hearing, frankly. Preliminary hearing is a mini grand jury probable cause hearing. The defense gets to ask all the questions, real tough questions, but the judge gets to err on the side of the prosecution. So in the scales of justice are even. What's good for the goose is good for the gander. But in the preliminary hearing, the way I understand the preliminary hearing, the judge gets to view the circumstances in the light that's most favorable to the prosecution. That being said, the defense can actually, cross-examine all the witnesses and ask about all the different evidence and poke holes in, the theory of the case as best as they can. And really, I was pushing for police courts. I would think it'd be awesome if, as soon as a person is arrested, they go through a 3-person panel who kind of, listens to the details of the beginning of the case and then writes it down and records it all. So that way you have it all for evidence. And the 3-person, a citizen panel, I call it a police because a cop would have to go to the 3-person panel. I think that's my understanding of what a police court is. Home rule cities allow police courts. So Sanford could have a police court, Alamosa could have a police court, Alamosa, Sanford, and Monte Vista. There's a couple home rule cities here in the SLV. Now there's other hearings. There's an evidentiary hearing. I mentioned that and he got all mad because, for whatever reasons, there's a status hearing. So to Mike Gonzales, these things also have a meaning. There's a pre-trial hearing, there's a status hearing, and there's evidentiary hearing. There's also an ombudsman hearing mentioned in the CRCP. So there's an ombudsman hearing also. The Victims' Rights Amendment also mentions a shit ton of hearings as well. So let me read the Victims' Rights and then get to the ombudsman if I can find it in time to where it's not a bunch of dead air. Post-conviction DNA test hearings, preservation of DNA evidence hearing. That's CRS 18-1. 4142B, tampering with evidence hearing, 2431-9022C. 2431-9022C. The filing of charges, these are all kind of redundant, but sentencing, resentencing hearing, disposition, a diversionary agreement hearing, a preliminary hearing, any bail bond hearing, initial modification, reduction, or removal. This is the victims can actually... These are all critical stages in the criminal justice system, and so all these critical stages in the criminal justice system, the victim can participate if they so choose. Typically, just a trial, right? Just a trial, maybe the preliminary hearing, but they don't really need to be around for the filing of the charges and the arraignment, guilty or not guilty, or nolo contendere. You got a motions hearing, and you got an evidentiary hearing, which I think is actually a preliminary hearing is an evidentiary hearing, but it's just a different name. Status hearing. What's the status of the thing? Pretrial readiness conference. We're about to do trial, and so that's the step right before trial. So there's pre-trial things, but I think a pre-trial is kind of a status hearing, but a pre-trial readiness conference is we're about to go to trial. Are you ready with all your witnesses, your evidence? How are you? Subpoena or application for, any subpoena, I guess, hearings or application for the alleged victim's education, compensation, mental health, medical history, other privileged records. That's 1390-107, the trial sentencing hearing. And then there's also the victim impact statement. So the victim impact statement, the hearing, that would be a sentencing hearing. Appellate review, so the appeal hearing, the appeal decision. And then there's the petition for expungement, so the expungement hearing. Modification of the no contact provision of the mandatory criminal protection under Section 18-1001 hearing. The appeal review or decision hearing. So there's a couple other hearings that the Victims' Rights Amendment adds. And then the Ombudsman's hearing. No freaking way I'll be able to find the Ombudsman here just flipping through it like this. But let's see if I can. So the Ombudsman hearing, I want to say, is at the... it's not the grand jury rules. I want to say it's probably back there in the discovery. So this is all the initial stuff. And so discovery is Rule 16. Subpoena is Rule 17. We're looking for the Ombudsman hearing. Omnibus. Okay, not an Ombudsman hearing. The Omnibus stage. There's a trial planning stage 2. Uh-oh. This is interesting. An exploratory stage. In all criminal cases and procedures prior to trial, there may be a need for one or more of the following 3 stages. Oh, I see. An omnibus hearing. A setting of the omnibus hearing. If a plea of not guilty or not guilty by reason of insanity is entered at the time the accused... What if not guilty by reason of sanity is arraigned? The court may set a time for and hold an omnibus hearing in all felony and misdemeanor cases. In determining the date for the omnibus hearing, the court shall... So there's the omnibus hearing. That's Rule 16. It's page 38 on this Criminal Rules of Procedure book. But I don't... Goodness gracious, Rule 16 goes on forever, don't it? Rule 16, depositions. Rule 16, discovery and procedure before trial. You got the defense side, the prosecution side. Something about protective orders, excision, in-camera proceedings, failure to comply, general proceeding requirements. There's a pretrial conference right here. Whenever a trial is likely to be protracted or otherwise unusually complicated, or upon request by agreement of the parties, the trial court may, in addition to the omnibus hearing, hold one or more pretrial conferences with trial counsel present to consider such matters as will promote a fair and expeditious trial. Matters which might be considered include making stipulations as to facts about which there can be no dispute, marking for identification various documents and other exhibits of the parties, excerpting or highlighting exhibits, waivers of foundation as to such documents, issues relating to co-defendant statements, severance of defendants or offenses for trial, seating arrangements for defendants and counsel, conduct of jury examination, including any issues related to confidentiality of juror, locating information, number and use of peremptory challenges, procedure on objections where there's multiple counsel or defendants, order of presentation of evidence and arguments where there's multiple counsel or defendants, order of cross-examination where there are multiple defendants, temporary absence of defense counsel during trial, resolution of any motions or evidentiary issues in a manner least likely to inconvenience jurors to the extent possible, and 15, submission of items to be included in a juror notebook. At the conclusion of a pretrial conference, a memorandum of the matters agreed upon should be signed by the parties, approved by the court, and filed. Such memorandum shall be binding upon the parties at trial and appeal and in post-conviction proceedings unless set aside or modified by the court in the interest of justice. However, admissions of fact by an accused, if present, should bind the accused only if included in the pretrial order and signed by the accused as well as his or her attorney. Juror notebooks and da-da-da-da-da. So that means there's a pretrial conference, right? So I only mentioned a pretrial readiness conference. So is that the same thing or is that a different thing? And then the omnibus hearing, is that two different? Is that another step? And then the omnibus hearing, it has, well, let's go ahead. The setting of the omnibus hearing. If a plea of not guilty or not guilty by reason of insanity is entered at the time of the accused is arraigned, the court may set a time for and hold an omnibus hearing for all felony and misdemeanor cases. In determining the date for the omnibus hearing, the court shall allow counsel sufficient time to 1. To initiate and complete discovery required or authorized under this rule. 2. To conduct further investigation necessary to the defendant's case. 3. To continue plea discussion. 3. The hearing shall be no later than 35 days after arraignment. Omnibus hearing. If an omnibus hearing is held, The court, on its own initiative, utilizing an appropriate checklist form, should 1. Ensure that there has been compliance with the rule regarding obligations of the parties. 2. Ascertain whether the parties have completed the discovery required in Part 1A, and if not, make orders appropriate to expedite completion. 3. Ascertain whether there are requests for additional disclosures under Part 1D. 4. Make rulings on any motions or other requests then pending, and ascertain whether any additional motions or requests will be made at the hearing or continued portions thereof. 5. Ascertain whether there are procedural or constitutional issues which should be considered. And 6. Upon agreement of the parties or upon a finding that the trial is likely to be protracted or otherwise unusually complicated, set a time for a pre-trial conference. Unless the court otherwise directs, all motions and other requests prior to trial should be reserved for and presented orally or in writing at the omnibus hearing. All issues presented at the omnibus hearing may be raised without prior notice by either party or by the court. If discovery, investigation, preparation, and evidentiary hearing or a formal presentation is necessary for a fair determination of any issue, the omnibus hearing should be continued until all matters are properly disposed of. Any pretrial motion, request, or issue which is not raised at the omnibus hearing shall be deemed waived unless the party concerned do not have the information necessary to make the motion or request or raise the issue. 4. Stipulations by any party or his or her counsel should be binding upon the parties at trial unless set aside or modified by the court in the interest of justice. 5. A verbatim record of the omnibus hearing shall be made. This record shall include the disclosures made, all rulings and orders of the court, stipulations of the parties, and an identification of other matter determined or pending. D. Omnibus hearing forms. The forms set out in appendix to Chapter 29 shall be utilized by the court in conducting the omnibus hearing. These forms shall be made available to the parties at the time of the defendant's first appearance. What? The first appearance? Nothing in the form shall be construed to make substantive changes of these rules. Appendix to Chapter 29. Chapter 29? Where's Chapter 29? So anyways, we got an omnibus hearing, and we have a regular pretrial conference, which could be the same thing as a pretrial conference. And, then do we have subpoena hearings? I think you could probably have a hearing for any goddamn thing. But those are the main hearings, right? So there's other hearings out there. At the very least, I got you 10 hearings. The San Luis Valley, Mineral County. I got you at least 10 steps. Maybe an evidentiary hearing, maybe a status hearing or a pretrial hearing, maybe not an ombudsman hearing, but an omnibus. An omnibus hearing. So I like that omnibus hearing. I also like that regular pretrial hearing because it seems like it's more specific. And then you have all these other, hearings that the victim's rights amendment had added. If you tremble with indignation at any instance of injustice, then you are a comrade of mine. If you tremble with indignation at any instance of injustice, you're a comrade of mine. The great thing about being a revolutionary is that you can see injustice anywhere it exists. There's 11 total judges. I think here's 10 judges, but there's a municipal judge in Alamosa. And since Sanford and Monte Vista can be home rule cities, there could be more than 11 judges. But we got 4 district court judges: Michael Gonzales, Amanda Hopkins, Kristen Newmeyer Olson, Kim Cortez Rodriguez, and 6 county judges. I'm pretty sure he probably got retained: Daniel Walzel, Alamosa County, John Stinger, Jason T. Kelly, Kimberly Wood, Ruth Atchison, Craig Schuneman, Saguache County, Mineral County, Castilla, Conejos, Rio Grande County, respectively. So John Stinger, Rio Grande, Jason T. Kelly, Conejos County, Kim Wood, Castilla, Ruth Atchison, Mineral County, Craig Schuneman, Saguache County. Now, injustice anywhere is a threat to justice everywhere. I believe in one for all for one. You think if the devil attacks an angel and you ignore it, you think that devil is going to stop being a devil? Einstein said, "Great spirits always encounter violence from mediocre minds. Do not think that I have come to abolish the law or the prophets." This is Jesus Christ. "I have not come to abolish them, but to fulfill them." Matthew 5:17. I can imagine an SLV where we have a court system that actually functions. Can you imagine if we have a court system where people say, "Hey, let's go to the legal system"? When the sheriff, you say, "I'm going to go to the legal system, to the sheriff," and they say, "Oh, okay, you don't have to do that. You want the people and the cops and the judges and lawyers to all be intimidated by America's judicial system. And especially the criminal motherfuckers. Doesn't everybody, the commissioners, legislative, executive, and judicial, care about public safety? Then how can there be crime all over the place? Crime, public safety is all three branches of government's responsibility. Can you imagine a court system that actually stops crime? Can you actually imagine a court system that not only stops crime, but that can root out who the innocent people are? You have a 10-step process. It's not just to fuck a person over. It's not a rocket docket slaughterhouse. It's to find out who's innocent and who's guilty. It's to find out the truth. What the hell actually happened? And what percentage do the different parties are they to blame, if any? Could you imagine if we had a court system that was rooted in truth and justice and love and peace? Can you imagine if we had a San Luis Valley that had the cops and the judges and a good district attorney? We don't want a great district attorney. We just want a good district attorney. And in 4 or 2 years, or 6 years if you get reelected, just let the San Luis Valley decide for itself if you were, great or just merely good. But aim to be good. Aim to be good. And let society judge for itself. A good cop is a good lawyer and vice versa. And so I would think the same for a DA. A good DA is a good judge, and a good judge is a good DA, and a good DA is a good cop and a good social worker. And a good cop and a good social worker and a good judge is a good DA. A good cop is a good lawyer, and a good lawyer is a good cop. A good cop is a good social worker, and a good social worker is a good cop. If you had a cop and a social worker, so you had a legal, mind, social worker, you had the empathy of a social worker, the legal mind of a lawyer, but the muscle of which the entire system depends, and you're not just a good cop, you're a great cop, you're a super fucking cop. And thank you to all the super cops. But could you imagine if we had a cop legal system, a cop, judge, and lawyer system that didn't just protect themselves, but they actually protected the 46,000 people here in the San Luis Valley? Could you imagine if we actually had a common law? If we actually had 25 laws that we all had to agree on? We all had to agree on, and those were the priority laws here in the Valley. These 25 things. You ever read Colorado law? You see that the laws just kind of go on and on and on. My friend, so million bottles of beer on the wall. And so you need somebody. They all have cheat sheets. They all got little cheat sheets. I want a common, not just a common law, the common rules. Don't murder, don't, assault, don't steal, and don't rape. That's the top 4 for Johnny Law, but I got top 10 too. But also a common criminal procedure. A nice 10-step common criminal procedure. So I think already for me and Michael Gonzales and for the rest of the SLV, I think if anybody in the Valley, if you're in Mineral County and some asshole says, hey, you're accused of some felony, you get a bail bond hearing, advisement of charges, preliminary, disposition, arraignment, motions hearing, pretrial readiness conference, and then there's a jury trial. You get 10 steps. And then the sentencing. You get 10 steps. Everybody in the Valley gets 10 steps if a judge is accused of a crime, if a police officer is accused of a crime. And actually, my God, Ann Kelly, since you're the brand new DA, if you really want to show us that you are fair and honest, what's good for the goose is good for the gander, you truly believe in injustice anywhere is a threat to justice everywhere, if you truly believe in the rule of law, then when a cop or a judge breaks a major law, especially a felony, don't start covering up felonies for the plutocrats, for the rich and powerful. Don't cover up any of the felonies. Don't bury any of them in the grand jury. Don't try to protect any of your buddies. They all got to go through the same 10-step procedure. And maybe they weren't your friend if they're going to go around committing crimes. What kind of friend would do something like that? Befriend the DA and then go commit a fucking major fucking thing and then put your entire career on the line just so to see if you're corrupt or not? And you'll want to defend your buddies, but then you got to give a shit about that person out in Mineral County, that widow and that orphan. That widow and that orphan that probably doesn't think that there's a DA or a police officer or a lawyer in the world or a judge in the world that gives a damn about them. But if they are robbed, if they are attacked, if they're assaulted, physically, sexually, if they're raped, if they're, shot and killed, if they have a major crime committed against them, the cops are going to take it serious. Everybody's on board with victims' rights. You need a victim. The whole system needs a victim. What the hell are you guys doing there if you're not protecting the victims? What the hell are you all doing? The cops, the judges, the lawyers all need to give a shit about victims' rights. And the more that the DA and Kelly articulates, the more that everybody else, not just the 46,000, but also the judges. A lot of times the DA will go into the courtroom and the judge will say, I'm the boss because I sit in the chair and I sit up here on high. None of these assholes can fire an information. They can't file an information. The whole system is about the DA filing an information. Now, there's some things they could do. They can call them up and say, hey, they can order them to file an information. So judges can order the prosecution to file an information. So if any of these assholes want to say it was all Alonzo Payne, all they had to do, Amanda, Krista, Kim, Michael, Daniel, John, Jason, Kim, Ruth, or Craig, was just order the DA to file an information, and then he would have had to have done it. If he didn't do it, then the judge could call him up and say, why didn't you do it? If it was capricious and arbitrary and he doesn't have a reasonable excuse, then he's got to do it. He's got to order it. You could also do a special prosecution, and there's some other tools that you got too. So a lot of these judges, I think, are going to, try to trick and pretend to everybody that they're the ones that have the power. They're the ones that are on high. But really, the DA is the one that files the information and then, pushes through the justice system. And the judge is either there for them or against them. Who knows? Depending, I guess, on their temperament and their ideology. But the more that she develops a consistent, uniform criminal procedure, Ann Kelly, and the more that Ann Kelly develops not just a nice 10-step uniform criminal procedure, I think that this 10-step criminal procedure will stand. It's good, and we'll all be on the same page with the 10-step criminal procedure, but also a common law. I'm pretty sure Michael Gonzales would say he's opposed to murder, but I don't know. I have never heard him say that, and he's not reassured me that he will make sure that I don't know which laws, criminal laws, which are priorities and not a priority to him. And in fact, there's like no sexual assault, but I didn't see rape anywhere. No rape, which is interesting. Why are we avoiding that language? If anything, maybe we could send Carol Riggenbach up there and just make rape a crime. Thou shalt not rape. But the more that the DA articulates, I saw Alonzo Payne, he had this one sheet of paper where it had, 10 crimes on one side and 10 crimes on the other side. So there's like 20 crimes that the Alonzo Payne administration was actually focused on. And people, everybody's fallible, everybody's human, so you're only limited to the finite, charges that you got either in your head or the ones that you wrote down. I mean, I wrote some down, but there are only 100 maybe, and there's a whole bunch that I didn't write down. So the more that she articulates a grand jury, I think she should head a grand jury. With the grand jury, she could do no wrong. Napoleon said that when you have the people backing you, right, like you could do no wrong or something. Whatever. It's not a great pithy. Einstein said, great spirits always encounter violence from mediocre minds.